place in the world to have your taxes prepared. So if someone wants to come to the best place for that, they'll have to come to Wentzville. As a matter of background, Liberty Tax Service is the third largest tax preparation service in the U.S. We're going faster than number 1 and number 2 combined, so it's our goal and plan to be number 1 by 2020. One of the things we're probably most well known for is for having employees dressed as the Statue of Liberty outside our place of business, waving to people as they pass by. And by the way, we're not waving at the cars and the trucks, we're actually waving at the people inside the cars and the trucks. 1 week ago, the day after I opened for business, we had our first waiver on the job. We have a couple of waivers here tonight, as a matter of fact. They're waving there. The waiver who was on duty or working at that time is not here with us tonight. But within a couple of hours, a nice gentleman by the name of John Boyer stopped in my office to tell me that we weren't allowed to do that. He stated that the city has an ordinance prohibiting living signs. I pointed out that we weren't holding any signs, and I'll point out that the young lady here tonight does have a sash that says Liberty, but the person that was out there on the street did not have anything that indicated our name, our phone number, nothing at all, just the standard Statue of Liberty costume that you can get on Amazon or lots of other places. Anyway, Mr. Boyer stated that the city had that ordinance and pointed out that that if we did not desist, that we could be charged with a fine of up to $500 for each occurrence. He was kind enough to send me a copy of section 405.585 dealing with prohibited signs and of section 405.590 dealing with rules and definitions. According to my understanding of these rules, I would be breaking the law just by walking outside my door of business into my parking lot dressed in that costume. I'm here tonight to request that the city reconsider that ordinance based upon several considerations. One of which is I think Mr. Boyer probably has a lot of other contributions he could be making to the city other than coming by and doing things like that. The other reason is that we've got a number of people that want to work for Liberty Tax Service waving to the public. We've hired 6 and we'll probably be hiring more as the tax season progresses. But the third, I think, more compelling reason is that I believe that the ordinance is unconstitutional. I'm not an attorney. I know the city has an attorney. I know David. This is Liberty Tax Service has experienced city ordinances in the past, and in every case, at least I'm told that in every case we have prevailed. I don't want to have to go to court. I've never taken anyone to court. I've never called the police on anybody. I've never had police call on me. That's not the way I operate. But I think it's important to look at the law, and when it comes to the laws on commercial advertising, the Supreme Court, in what is considered somewhat of a landmark case in this area, in 1980, the case of Central Hudson Gas and Electric Company versus the Public Service Commission, ruled that regulations banning promotional advertising by Central Hudson violated their constitutional rights. In so doing, they laid out a 4-part test for determining when the restrictions on commercial speech violated the First Amendment of the U.S. Constitution. And it lists those 4 conditions on your page. One of which is that Is the regulation more extensive than is necessary to serve that interest? And does the regulation directly advance the governmental interest asserted? In 1993, there was another test case with the City of Cincinnati versus Discovery Network. In this case, the Supreme Court struck down a municipal regulation as an unconstitutional restriction of commercial speech. Discovery Network published a free magazine advertising adult programs, which was dispensed from freestanding news racks placed on city sidewalks. The city ordered Discovery Network to remove its news racks pursuant to an ordinance prohibiting distribution of commercial handbills on the public right-of-way. The city stated the goal of the regulation was to ensure safe streets and regulate visual blight. Might sound familiar. The court held that the regulation was not a reasonable means of achieving its stated goals, and the court cautioned against placing too much importance on the distinction between commercial and non-commercial speech, especially where the distinction bears no relationship to the particular interests asserted by the city. This was reaffirmed in the recent case of Citizens United, the aspect of commercial speech versus individual speech. Mattress Outlet. In 2005, Kitsap County versus Mattress Outlet, the Supreme Court of Washington, now this is Supreme Court of Washington, the other was Supreme Court of the U.S., found that the county's sign ordinances were overbroad as well as unconstitutional restriction of free speech. Mattress Outlet operates a retail mattress business. One of their advertising techniques is to pay individuals who wear yellow oversized raincoats that display Mattress Outlet's name, address, and telephone numbers, and to stand on public sidewalks and wave at passersby. Sound familiar? According to the court, the general rule is that the speaker in the audience, not the government, assesses the value of the information presented. The court ruled that an ordinance must directly and materially serve the governmental interest. The burden is not satisfied by mere speculation or conjecture. Rather, a governmental body seeking to sustain a restriction on commercial speech must demonstrate that the harm it recites are real and that its restrictions will in fact alleviate them to a material degree. Here is in Discovery Network, prohibiting persons from wearing signage provides minimal, if any, benefit in aesthetics and safety. There was no evidence that Mattress Outlet signs had any effect on traffic safety. Mere speculation of harm will not justify a limitation on the exercise of the right of free speech. Again, the court cautioned that the ordinance distinguishing between commercial and non-commercial speech does not bear any relationship to the county's interest.
Sir?
Yes?
And I don't want to cut you off, but we did, I want you to get to your point because we
Okay.
do limit the time.
Okay, thank you. I will. I only have one more case, but I'll skip that. Therefore, if Wentzville believes there is compelling public need to ban people dressed in costumes for commercial purposes, then it must also ban anyone dressed in costumes, including Santa Claus and children dressed in Halloween costumes, unless the city can prove that the distinction bears directly on the city's interest in aesthetics and safety or other compelling interest. Likewise, if the city wants to prohibit banners and pennants and similar signs, the city bears the burden of proof that such signs pose a greater harm than the type of signs that are permitted. I'm aware I didn't bring that, but I'm aware that all city, county, and state employees recite an oath of office to uphold the Constitution of the United States as well as the Missouri Constitution. I think you're all familiar with the First Amendment, which there shall be no law abridging the freedom of speech, but let me just point out, Missouri Constitution is even more specific. Article Article 1, Bill of Rights, that no law shall be passed impairing the freedom of speech, no matter by what means communicated. I request that, since you all swore an oath to uphold those constitutions, that you have a duty to reevaluate that constitution, to reevaluate your ordinance. And I request that, I'm sure that you will want to consider this before making a ruling, but I also request that until you give it due consideration, that you consider putting a stop to the enforcement of that ordinance until you've had a chance to review it further. One more item, and that is that the ordinance specifically says that non-commercial speech is not included. Therefore, until the council either changes the ordinance or holds off enforcement of the ordinance until they can consider it further, I intend to have my people dressed in the Statue of Liberty costume